In this case brief, I have Wallmuth versus Rapids. Facts of the case. Joshua Wallmuth was an 8th grade student who was attacked by 3 students, kicked by one of them in a physical education class in the back corner of a locker room after class during dressing time. One student had threatened Wallmuth during class that he would get him. Wallmuth testified he thought the threat wasn't serious and felt no danger or harm going into the locker room. He thought the boy had cooled off. Wallmuth claimed the kick severely injured his knee. 30 to 60 seconds after the incident, the PE teacher came into the locker room on his regular patrol and found Wallmuth on the floor. Initially, the trial found the school board 100% liable for Wallmuth's injuries, failing to supervise students. The Court of Appeals found the school board was liable for 70% of Wallmuth's injuries due to unreasonable supervision. Some of the facts on this case. Wallmuth testified that the PE teacher was not there when he was being attacked and hardly ever supervised the locker room. Wallmuth also claimed that there were lots of locker room incidences previous to this directed at him, and the PE teacher never saw them. He admitted he never told the PE teacher about them and didn't tell the PE teacher about the in-class threat prior to the incidents. Issues that arose in this case is this case questioned whether the lower court erred in finding the school board liable for Wallmuth's injuries. And the holdings that were found, the Supreme Court reversed and rendered the lower court decision and dismissed Wallmuth's claim against the school board. In reviewing the jurisprudence throughout the state, we find that the vast majority of courts have found no liability on the part of school boards for fights occurring between students or accidents at school, either because the school board did not breach its duty of reasonable supervision or because the school board or school personnel could not have prevented the instances from occurring. The legal rationale in this case is before liability can be imposed on the school board for failing to adequately supervise the safety of students, there must be proof of negligence in providing supervision and also proof of causal connections between lack of supervision and the accident. Also, before the school board can be found to have breached the duty of adequate supervision, the safety of students, the risk of unreasonable injury must be foreseen, constructively or accurately known, and preventable if request degree of supervision had been exercised.